Good day everyone, especially to Ma'am Ledeline Unlad. First, let me introduce myself. I am Jane Elmedulan of Electronics 1. By the way, I am one of the reporters in Malolos Constitution. The first 24 articles are already discussed by Mr. John Mark Marsamolo. So here's the continuation of the topic Malolos Constitution. But before we proceed, let us have a short recap of Malolos Constitution. What is Malolos Constitution? It is the political constitution of 1899, informally known as the Malolos Constitution, was the basic law of the First Philippine Republic. It was written by Felipe Calderon y Roca and Felipe Buencamino as an alternative to a pair of proposal to Malolos Congress by Apolinario Mabini and Pedro Paterno. After a lengthy debate in the latter part of 1898, it was enacted on January 21, 1899. Article 24. Any foreigner can freely reside in the Philippine territory, subject to the dispositions regulating the matter, practice his profession therein, or engage in any work that may be performed without the certificates of aptitude issued by public authorities and required under the law. So, ang sinumang dayuhan ay maaaring malayang manirahan sa teritoryo ng Pilipinas kahit walang mga sertipiko ng aptitude na ibinigay ng mga pampublikong otoridad at kinakailangan sa ilalim ng batas. Article 25. Any Filipino who is in the full enjoyment of his political and civil rights cannot be prevented from leaving the territory freely, nor can he be hindered from transferring his residence and properties to a foreign country except when he is required to render military service or maintain public charges. Ang sinumang Pilipino na may karapatang pampolitika at sibil ay hindi maiiwasan na umalis ng malaya sa teritoryo o mapipigilan man sa paglipat ng kanyang tirahan at mga pag-aari sa isang banyagang bansa maliban kung kinakailangan niya maglingkod sa militar. Article 26. Any foreigner who is not naturalized cannot exercise any office in the Philippines that carries any authority or jurisdiction. When we say foreigner who is not naturalized, it is the foreigner that is not admitted to the citizenship in the country. Hindi sila maaaring gumamit ng anumang tanggapan sa Pilipinas na nagdadala ng anumang otoridad o jurisdiction. Article 27. Every Filipino is required to rise in arms to defend the motherland whenever he is summoned by the law, and to contribute to the expenses of the state in a manner proportional to his means. So, ang bawat Pilipino ay kinakailangang tumaas sa bisig upang ipagtanggol ang inang bayan tuwing siya ay pinapatawag ng batas at upang magbigay ng kontribusyon sa gastos ng Estado sa paraang proportional sa kanyang mga kinikita. Example dito ay ang pagbabayad ng taxes buwan-buwan. Article 28. The enumeration of the rights guaranteed under this title does not imply the prohibition of any other right not expressly stated herein. So, ang bilang ng mga karapatang ginagarantiyahan sa ilalim ng pamagat na ito ay hindi nagpapahiwatig ng pagbabawal ng anumang iba pang mga karapatan na hindi malinaw na nakasaad dito. Article 29. Previous authorization shall not be required to prosecute public official before the lower courts, whatever the offense they have committed may be. A superior order shall not exempt a public official from his responsibility in cases where there is a manifest, clear, and peremptory infraction against a provision of the Constitution. Otherwise, it will only exempt agents who do not exercise any authority. So, ang naunang pahintulot ay hindi kinakailangan upang mag-usig ng pampublikong opisyal sa harap ng mga mababang hukuman, anuman ang pagkakasalang ginawa nila. Ang isang nakahihigit na katutusan ay hindi dapat maibukod sa isang opisyal ng publiko mula sa kanyang pananagutan sa mga kaso kung saan mayroong isang maliwanag, malinaw at walang katuturan na paglabag-laban sa isang probisyon sa saligang batas. Article 30. The provision guaranteed in Article 7, 8, 9, 10, and 11 and paragraphs 1 and 2 of Article 20 cannot be suspended for the entire Republic or for any of its parts, except temporarily and by means of a law whenever the security of the state so requires under extraordinary circumstances. So, ang mga probisyon na ginagarantiyahan sa Artikulo 7, 8, 9, 10 at 11 at talata 1 at 1 ng Artikulo 20 ay hindi maaaring suspindihin para sa buong republika o para sa alinman sa mga bahagi nito. However, in no law can other rights be suspended aside from those provided for in the first paragraph of this article, nor shall it authorize the government to exile or deport any Filipino from the country. So, gayon pa man, sa anumang batas ay hindi maaaring masuspindi ang ibang mga karapatan bukod sa mga itinadhana sa artikulong ito. In no case can military or civil officials establish another punishment other than what has been previously prescribed by the law. Sa anumang kaso, hindi maaaring magtatag ng ibang parusang opisyal ng militar o sibil maliban sa naunang inirekomenda ng batas. Article 31. Nobody in the Philippine Republic can be brought to trial under privative laws or in special courts. No person or corporation can have privileges or enjoy emoluments that are not obtained as compensation for public service and determined under the law. Army and Navy laws shall only apply to crimes and offenses closely related to the military and naval discipline. So, walang sinuman sa Republika ng Pilipinas ang maaaring mapasyahan sa ilalim ng mga batas na pribado o sa mga espesyal na korte. Walang sinumang tao o korporasyon ang maaaring magkaroon ng mga pribilehiyo o masiyahan sa mga emolumento na hindi nakuha bilang kabayaran sa mga serbisyong publiko at natutukoy sa ilalim ng batas. Article 32. No Filipino can establish major acts or institutions that entail property or accept honors, distinctions, honorific titles, or titles of nobility from the foreign nations, without the authorization of the government. Neither can the government of the Republic establish the institutions aforementioned in the preceding paragraph, nor can it confer honors, distinctions, honorific titles, or titles of nobility to any Filipino. The nation, however, shall award by means of a special law approved by Assembly the distinguished services rendered by its citizens to the motherland. Walang Pilipinong maaaring magtatag ng mga pangunahing kilos o institusyon na nasasangkot ng pag-aari o tumatanggap ng karangalan, pagkakaiba, marangal na titulo o titulo ng maharlika mula sa mga dayuhang bansa nang walang pahintulot ng pamalaan. Gayon na din ang gobyerno ng Republika. Title 4 on Legislative Power. Article 33. Legislative power shall be exercised by an assembly of representatives of the nation. This assembly shall be organized in the form and conditions determined by the law enacted for such purpose. Ang pagpupulong na ito ay aayos sa anyo at mga kondisyon na tinutukoy ng batas na nasa ibatas para sa naturang hangarin. Article 34. The members of the assembly shall represent the entire nation and not only the voters who elected them. So, ang mga miyembro ng assembly ay dapat kumatawan sa buong bansa at hindi lamang ang mga botante na naghalal sa kanila. Article 35. No representative can receive any imperative mandate from his voters. So, walang representante na makakatanggap ng anumang utos na kinakailangan mula sa kanyang mga botante. Article 36. The Assembly will convene every year. It is the duty of the President of the Republic to convoke it, suspend and close its sessions, and dissolve it, with its concurrence or with that of the Permanent Commission, in the absence of the former and within the period guaranteed under the law. Ang Assembly ay magtitipon bawat taon. Tungkulin ng Pangulo ng Republika na kubinsihin ito, suspindihin at isara ang mga sesyon nito, kasama ang pagsang-ayon o ng Permanent Commission kung wala ang nauna at sa loob ng panahong ibinigay sa ilalim ng batas. Article 37. The Assembly shall be open for at least 3 months in a year with the time spent in its organization excluded from this period. The President of the Republic shall convoke it on the 15th of April at the latest. Ang Assembly ay bukas sa hindi bababa sa 3 buwan sa isang taon na may oras na ginugol sa samahan nito na hindi kasama sa panahong ito. Article 38. In extraordinary cases, he can convoke it outside the period granted under the law, with the concurrence of the Permanent Commission, and extend legislative work, provided that the extension shall not exceed the period of 1 month, and that it shall not be held for more than twice within the same legislature. So, sa mga hindi pangkaraniwang mga kaso, maaari niya itong kumbinsihin sa labas ng panahon na ipinagkaloob sa ilalim ng batas. kasama ng pagsang-ayon ng Permanent Commission at palawigin ang gawaing pambatasan sa kondisyon na ang pagpapalawak ay hindi dapat tumagpas sa panahon ng 1 buwan at hindi ito gaganapin para sa higit pa kaysa sa 2 beses sa loob ng parehong legislatura. Article 39. The National Assembly together with extraordinary representatives shall form constituent body in order to proceed to the reform of the Constitution and the election of a new President of the Republic. It shall be convened at least a month prior to the expiration of the powers of the former. In case the President of the Republic dies or resigns his office, the Assembly shall convene immediately on its own, either through the initiative of its President or that of the Permanent Commission. Ang Pambansang Asembleya kasama ang mga pambihirang kinatawan ay bubuo ng isang nasasakupan upang magpatuloy sa reforma ng konstitusyon at ang halalan ng isang bagong Pangulo ng Republika. Kung sakaling ang Pangulo ng Republika ay mamatay o magbitiw sa tungkulin, ang Asembleya ay magpupulong kaagad alinman sa pamamagitan ng pagkusa ng Pangulo nito o ng Permanent Commission. Article 40. While the new President of the Republic has yet to be named, his duties shall be exercised by the President of the Supreme Court of Justice, who in turn shall be substituted in his duties by one of the members of this said tribunal in accordance to the laws. Habang ang bagong Pangulo ng Republika ay hindi pa mapangalanan, ang kanyang mga tungkulin ay dapat gampanan ng Pangulo ng Korte Suprema ng Hustisya, na siya naman ang papalit sa kanyang tungkulin ng isa sa mga miyembro ng nasabing tribunal alinsunod sa batas. Article 41. Whatever meeting of the Assembly held outside the ordinary period of legislation shall be illegal and void, except in the case provided in Article 39, or in the event when the Assembly is convened as the Court of Justice, in which case no function can be exercised other than its judicial power. Ang anumang pagpupulong ng Asembleya na gaganapin sa labas ng ordinaryong panahon ng batas ay magiging labag sa bisa at walang bisa, maliban sa kaso ng itinadhana para sa Artikulo 36 o sa kaganapan kapag ang Asembleya ay pinapatawag bilang isang hukuman ng hustisya, kung saan sa anumang kaso ay hindi maaaring gampanan maliban sa kapangyarihan nito sa panghukuman. Article 42. The sessions of the Assembly shall be done in public. However, they can be held privately upon the request of a certain number of its members determined under its bylaws, with the decision afterwards through an absolute majority of voters among its members in attendance if the discussion on the same subject should continue in public. Ang mga session ng Asembleya ay dapat gawin sa publiko. Gayunpaman, sila ay maaaring gaganapin ng probado sa kahilingan ng isang tiyak na bilang ng mga kasapi nito na tinutukoy sa ilalim ng mga batas. Article 43. The President of the Republic shall communicate with the Assembly through messages that shall be read from the tribune by a Secretary of Government. The Secretaries of Government can enter the Assembly with the right to be given the floor if they so wish, and can be represented in the deliberation of any particular bill by invoice designated by the President of the Republic. Ang Pangulo ng Republika ay dapat nakipag-usap sa Asembleya sa pamamagitan ng mga mensahe na babasahin mula sa tribune ng kalihim ng pamahalaan. Ang mga sekretaryo ng pamahalaan ay maaaring pumasok sa Asembleya at maaaring kinatawan sa pag-uusap ng anumang partikular na panukalang batas ng mga envoy na itinagala ng antas ng Pangulo ng Republika. Article 44. The Assembly can be convened as a court of justice to pass judgment on crimes against the security of the state by the President of the Republic and members of the Council of Government, by the President of the Supreme Court of Justice, and by the Solicitor General of the nation, and by means of a decree issued by the Assembly itself, or by the Permanent Commission in the absence of the former, or by the President of the Republic upon recommendation of the Solicitor General or the Council of Government. The laws shall determine the procedures for accusation, investigation, and pardon. Ang Asembleya ay maaaring ipatawag bilang isang hukuman ng hustisya upang ipasa ang hatol sa mga krimen laban sa seguridad ng Estado ng Pangulo ng Republika at mga miyembro ng Konseho ng Pamahalaan ng Pangulo ng Korte Suprema ng Hustisya at ng Solisitor Pangkalahatan ng Bansa sa pamamagitan ng isang antas na inisyon ng Asembleya mismo o ng Permanent Commission ng wala ang nauna o ng Pangulo ng Republika sa rekomendasyon ng Solicitor General o ng Konseho ng Pamahalaan. Tutukuyin ng mga batas ang mga pamamaraan para sa akusasyon, pagsisiyasat at kapatawaran. Article 45. No member of the Assembly can be persecuted or harassed for whatever opinion he expresses, nor are the votes that he casts in the exercise of his office. So, walang membro ng Asembleya na maaaring pag-usigin o asarin para sa anumang opinyon na ipinahayag niya o para sa mga boto na ibinato niya sa pagpapatupad ng kanyang tanggapan. Article 46. No member of the Assembly can be prosecuted on criminal matters without the authorization of the Assembly or of the Permanent Commission, to which an account of the matter shall be immediately rendered for the appropriate resolution. Imprisonment, detention, or arrest of a member of the Assembly cannot be done without prior authorization from the Assembly or from the Permanent Commission. However, once the Assembly has been notified about the warrant of arrest, it shall be held liable if, within the next 2 days after notification, it does not authorize imprisonment or manifest the reasons for refusing the same. Walang miyembro ng Asembleya ang maaaring kasuhan sa mga kriminal na bagay nang walang pahintulot ng Asembleya o ng Permanent Commission. Gayunpaman, kapag naabisuhan ng Asembleya tungkol sa bisa ng pag-aresto, mananagot ito kung sa loob ng sumusunod na 2 araw pagkatapos ng pag-abiso, hindi nito pinapahintulutan ang pagkukulong o ipakita ang mga kadahilanan para sa pagtanggi sa pareho. Article 47. The National Assembly shall also have the following powers. Number 1. Create bylaws for its internal governance or lumikha ng mga batas sa panloob na pamamahala. Number 2. Examine the legality of election and legal aptitude of the members or suriin ang legalidad ng halalan at legal na kakayahan ng mga nahalal na kasapi. Number 3. Upon its convocation, appoint its president, vice president, and secretaries, provided that the Assembly is not dissolved, its President, Vice President, and Secretaries shall continue exercising their office for 4 terms. So, sa pagkakumbok nito, italaga ang Pangulo, Vice Presidente, at Sekretaryo. And number 4, accept the resignation presented by its members and grant leaves of absence in accordance to the bylaws. So, tanggapin ang pagbitiw na ipinakita ng mga kasapi nito at pagbigyan ng kawalan ng pagliban alinsunod sa batas. Article 48. No bill may be passed into law without being submitted into a vote in the Assembly. The presence of at least a 4th part of the total number of members whose selection has been duly approved and have been sworn to office is required in order to pass a law. Walang panukalang batas na maaaring maipasa sa batas nang hindi isinumite sa isang boto sa pagpupulong ang pagkakaroon ng hindi bababa sa ika-4 na bahagi ng kabuoang bilang ng mga kasapi na ang kahalalan ay naaprubahan ng maayos at kinakailangan upang makapasa ng isang batas. And that would be all. Thank you for watching and listening, and God bless.